Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is Texas lien waivers, best practices and gotchas to look for. So without further ado, I'd like to introduce the fabulous Rebecca Hicks.
Well, good morning, everybody. So this is a subject matter that, I get excited about, but not a lot of people get excited about. Lien waivers in Texas used to be just the wild, wild west. Everybody was fighting over the types of forms. We always had to try to negotiate the type of lien waiver or the form of the lien waiver. But about I think it's 3 legislative sessions ago now, the Texas legislature said, this is stupid, no more. So now we have statutory form lien waivers for Texas. So today, our presentation is going to mainly focus on those statutory form lien waivers, which one to use and when, and also what to do if you actually get a lien waiver that is not in the statutory form. How do you handle that situation? So let's do it. Here, well, first of all, I guess let's all make sure we understand what am I talking about when I say a lien waiver. A lien waiver is nothing more than a representation that either you have been paid, meaning the money is in your company's bank account, it's there, or you will be paid out of the next draw. That is what a lien waiver is. So that's why what we're trying to do is owners and general contractors are looking for some assurance that, hey, you've been paid or you're going to be paid, so that you're not going to assert a mechanic's lien later. That's why what all the fuss is about with these lien waivers, right? So in Texas, our lien laws are found in Chapter 53 of the Texas Property Code. So that's where we always are going to look for private projects as far as what are the rules, how do I do a lien, everything lien related for private projects, meaning somebody, a company owns it or individuals own it. It's not a government job. Government jobs are governed by different rules. But for private projects, which is the majority of jobs folks work on, Chapter 53 of the Texas Property Code is where we look. And back when the Texas legislature said we've got to stop all this fighting about lien waivers, it's screwing up the construction process, that's where they published these statutory form lien waivers. They actually have, in this is kind of uncommon to see that they're actually full-fledged, word for word lien waivers, 4 different forms actually published in the statute. And there's also a portion of the statute that says if you do not use these forms, your lien waiver may not be enforceable. So at this point for private projects, everyone should be using these statutory lien waivers. And here are the 4 types that are published there that are purely from Chapter 53 of the Texas Property Code. You've got a conditional waiver and release on progress payment, an unconditional waiver and release on progress payment, a conditional waiver and release on final payment, and an unconditional waiver and release on final payment. And we're going to talk about when and how you use each of these forms. And I'm going to show you on the screen the exact statutory language that we're talking about. So, when should these forms be used? The forms that we're talking about, these Texas Property Code Chapter 53 forms, they're specifically designed for use on private projects. So if you happen to be doing, let's say, TxDOT work or federal government work, technically these forms do not apply to that type of project. They apply to private construction. So anything commercial, strip malls, high-rise buildings, apartment complexes, those are all types of examples of private projects. If you're working on maybe a school, TxDOT job, fire station, these rules don't technically apply. Can you still use these forms? Would they still be effective? Yes. So when in doubt, just use the form. These forms are also technically designed to be used before a mechanics lien is filed. So there's actually a section in Chapter 53 of the Texas Property Code that says once the mechanics lien has actually been filed, then these forms don't apply. But again, there's nothing wrong with using the form anyways. The statute doesn't say don't use it. It doesn't say it's illegal to use it. It just says, hey, these are really only applicable before. So we use these forms regularly, even after mechanics liens have been filed. So, again, when in doubt, use the form. It's important to use these forms correctly. That's why I kind of want to go through all of the 4 forms so that you know which form should be used and when, so that you're not using the incorrect form, because there's a lot of confusion. So you'll notice that there's 2, we've got 4 forms. So 2 of the forms are intended to be used for progress payments, and 2 of the forms are designed to be used for final payment. And the big difference between those is conditional and unconditional. So what's the big deal between conditional and unconditional? Conditional forms should be used anytime that the money is not already in your company's bank account. Unconditional forms should only be used when you actually have the funds in the bank account. So what do I mean by that? A check is not payments. You cannot sign and provide an unconditional form of waiver in exchange for a check. Because what is a check? A check is a promise to pay. A check does not mean the money is in your company's bank account. Because if you sign one of these unconditional forms of lien waiver in exchange for a check, and that check doesn't clear, you have arguably lost and waived your lien rights, because you have provided the wrong form in exchange for a check if you have provided an unconditional form of release. If you don't hear anything else I say today, please listen to this portion. Do not provide an unconditional form of lien waiver in exchange for a check. It can put you in a world of hurt if that check bounces or is returned for insufficient funds. So checks are not payments. You use the unconditional form only when the money is in your company's bank account and cannot be returned for insufficient funds. Sometimes banks have a waiting period for when something can be returned in SF. Sometimes that waiting period can be up to 2 weeks. Make sure you know what that waiting period is. Do not provide an unconditional form of lien waiver until it has passed. That's the way, if you want to actually preserve your right to payment, that's what needs to happen. So let's talk about these 4 forms of notices. First, we've got the conditional waiver and release on progress payment. So when should you use this statutory form, the one that's titled conditional waiver and release on progress payment? You use this form when your company will continue to supply equipment or material or continue to work on the project. So you're not done. You have not submitted a final invoice. You have not submitted a final pay application. Your equipment's still on the job if you're an equipment rental, or you're still going to be supplying product to the job. You use this for progress when it's the job is still in progress. You use this when payment has not been received on some of the invoices. So that means the money is not in your bank account, right? Either this conditional form could be exchanged for a check. That would be perfectly fine for a progress payment check. Using the conditional form is great. If the payment is by check or ACH, the funds have not been received in your company's bank account. So, an ACH payment takes a day or 2 to actually hit your bank account. So just because you've received notice that there was an ACH payment made doesn't mean those monies are in there. So again, you would provide the conditional form of waiver. So here on the screen is the actual statutory language. This is seriously just a copy and paste of the language. We've got some notes in how you fill in the blanks that will need to be filled in on this waiver. So this is a conditional waiver and release on progress payment form. You're obviously going to have to fill in your project name, address at the top. The form has a place for a job number. So if there is a job number, fill that in. If there is not a job number, many projects do not have a job number, just put in the not applicable because you don't have a job number, or leave that portion blank. Now, in the body of this waiver, notice with this conditional form, that first sentence that says, on receipt by signer of this document of a check from blah, 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 and when the check has been paid by the bank on which it is drawn, meaning the check cleared, that's what that means, then this release becomes effective. That's why you use this conditional form in exchange. If you want to exchange a release for a check, that's what this form is designed to do. This conditional waiver, because of the specific way it's worded, is only effective after that check clears. That's why we use that form in this form in that circumstance. You're also going to have to fill in the owner's name below where it says the property of owner. Located at, you're going to need to put in the address and location of the project. And then you see the part that says to the following extent. That's the part I want you to focus on. This is where folks mess up these waivers too, because to the following extent, that's where the statutory language stops. That's where you have to fill in what is the extent of this waiver. If you get that extent wrong, you have probably just waived your lien rights to things that you didn't intend to. So here is kind of the way we fill these forms out, an example of how we would fill this conditional release on progress payment out for one of our equipment rentals. Rental equipment furnished by fictional rental company in connection with the project. And then you define the project as described in fictitious invoices numbers, and you list out the actual invoice numbers that you're intending to release. Some people try to fill this out with just for electrical supplies and leave it there, or for they'll put in a down date. They'll put in for labor materials provided between this date and this date, or labor materials provided prior to January 31st, 2025. And those really aren't specific enough to really protect you. If you're going to use a down date, you need to be darn sure that you have been paid every cent, or the check will make payment for every cent that was incurred for work done before that date. What does that mean? If you submit a change order later for work that was done prior to January 31st, 2025, but you've signed a waiver that has a January 31st, 2025 down date, you may have just waived your right to that change order. That's why it's much better to just tie it specifically to either the invoices or the pay applications that are actually being paid. That's why we recommend that you fill out this portion of the waiver that says to the following extent, in a very specific way, tying it to your particular invoices or pay applications being paid. Also note where we see folks messing up this conditional waiver release on progress payment. In that second paragraph there, it talks about as indicated on the attached statements. What does that mean? This form, the form by our legislature, I didn't write this, anticipates that you are going to attach either a statement of account outlining what's been paid or copies of your invoices or pay applications to this waiver, so that there's never a doubt as far as what you're waiving. What are you waiving your rights to? These specific invoices, these specific pay applications. So the attachment should be there. That's how this form's designed to work. And we're not going to go over this level of detail as far as how you fill out these blanks on all four waivers, because they're similar and you'll fill them out the same type of way. But I wanted to really, really draw your attention to making sure you limit that to the following extent portion, so that you're not unintentionally waiving your rights just by placing very broad language in that blank, right? So what is our next type of form that you could use in the Chapter 53 forms is the unconditional waiver and release on progress payment. So when do you use this form? You use this form when your company will continue. So you're going to continue to supply product or work on that job. You're not done. You haven't submitted a final pay application. You're not done. But the payment has already been received. That's when you provide this form. Now, you recall when we were talking about the conditional waiver form just now, I called your attention to the language that says, hey, this form becomes effective once the check has been paid by the bank. If you provide a conditional waiver, you technically do not then have to go ahead and provide an unconditional waiver. The way that the Texas legislature designed these releases to work is that if you provide that conditional waiver, it becomes effective as a waiver once the check clears. So why would you need a separate form of a quote unquote unconditional waiver when you've already got an effective waiver the moment that check clears? But many owners and general contractors do not understand what I just told you. And so sometimes they will request after the check clears, they will then request both forms. So they'll then say, hey, I know you gave me this conditional waiver, but can you now give me the unconditional? As long as the check has cleared, it's fine to send them the form. I wish that folks would actually read the statutes and not require all that. They're doing extra work that they shouldn't have to do. They're requiring you to do extra work you shouldn't have to do. But there's nothing wrong once that check is cleared with providing them with the copy with an unconditional waiver in addition to the conditional that you may have already provided. Again, you want to limit this one to only the invoices paid. So here's exactly what this unconditional waiver on progress payment looks like. This is statutory language. This is directly from the statute. This is not Rebecca on the law. You'll see the part at the top, that notice in all caps at the top. That's from the statute. The legislature wants you to be very careful when using this form. That's why they put that there. They want you to understand that you should not be signing this form if you have not received the money in your bank account. It should not. That's why that's there. So what's the risk? If you actually use this form and the money has not been received in your bank account, or you use this form in exchange for a check that then bounces, too bad, so sad. We warned you. It's all caps right there on the top of the notice, right? So pay heed to the notice. And then these other blanks that you'll fill out in the notice are very similar to what we just talked about in the unconditional form. Just being careful when you get to the following extent. That's what you're limiting that language so that it's limited to the invoices actually being paid or the pay applications actually being paid. So what's the third type of form of lien release or lien waiver that you could choose to use or need to use in a particular circumstance? Conditional waiver and release on final payment. So this one is the form that you will use when you will not be supplying any further labor materials to the project. You're done. And you've sent your final, you're signing this as part of your final payment, receipt of your final payment. You use this conditional form when either in exchange for a check or when the monies have not been received by your company yet. You can send a conditional form even with your pay application. Some GCs or owners require that, and that's fine. The conditional waiver is going to be fine because it's specifically conditioned on you receiving payment later, right? It's not effective until the payment is received. So this one would be for your when the final payment has not been received, you're going to be using this conditional form of waiver. And so this is exactly the statutory language. And if you need copies of these forms, you can either just Google it, Texas Statutory Form Lien Waivers, and find it. If you want to shoot me an email, we'd be happy to tell you exactly where those are. I know SunRay also provides lien release, lien waivers. So talk with your SunRay representatives as well. And then what is our fourth form of lien waiver under the Texas statutes? An unconditional waiver and release on final payment. So when do you use this form? You use this form when you have received your final payment. The money is in your company's bank account for your final payment on the job. There's not going to be any more change orders. There's not going to be any more punch list work that you might bill for. There's not going to be any of those things. That the final payment has been received. That's when you use this for. This expects to cover every single penny that could be owed to your company has been paid, already been paid. Not that you're going to receive a check, but the money's already in your company's bank account. That's when you use this unconditional and waiver and release on final payment. And this again, the statutory language. That's exactly what this is on your screen right now. Here you'll notice that language at the top, very all caps language that the legislature really wants you to pay attention to, which says, hey, don't sign this if you haven't actually received the money. And you should know that it's actually illegal for a general contractor or a owner to ask you to sign an unconditional form of waiver if you have not been paid. The statute says that they should not be able to do that, that it's illegal for them to do that. Is it still happening every day? Yes, it is. Yes, it is. So the burden is on us, as supplier or subcontractors, to take a look at these forms carefully and make sure we're using the right one. Do not sign an unconditional form unless you've actually received the money. So what happens if you actually sign the wrong form of waiver? We do not have a definitive answer on that yet. Nobody has actually litigated up to the appellate level where a court has provided an opinion, to my knowledge at least, where they've signed one of these unconditional forms but did not receive payments. I wouldn't want any of you listening to this seminar to be the test case. So just pay attention, because since that language is so clear, it's all caps at the top of the notice. The courts may very well enforce that and say, hey, too bad, so sad. You signed an unconditional waiver. You shouldn't have done that. So you're out of luck. So don't let your company be the test case. What if your down date is wrong? Again, that's one of those that gets litigated. So if you sign a waiver that says you've been paid for everything through January 31st, 2025, but then you actually submit a change order, or there was one invoice with the date before that, or with product that was delivered before January 31st, 2025, have you just waived your right to payment for those products or that work? Arguably so. There's no definitive case law on that, to my knowledge. Don't be the test case. So when the legislature implemented these statutory forms, they also implemented something that I think a lot of people are unaware of, is that you no longer have to notarize lien waivers. They did that because the notary requirement for lien waivers was slowing down the construction process, because a lot of smaller subcontractors were not able to get in front of a notary as easy as, those of us that have a notary on staff. So that we could just walk out there and say, hey, can you notarize this? So the legislature actually said that you no longer have to actually notarize these forms. When you look up these statutory forms in Chapter 53, there's no place for a notary, because they do not have to be notarized. Is there anything wrong with notarizing it? No. Are some general contractors and owners still requiring a notary? Yeah. Do they have to do that? No, they don't. Notaries are no longer actually required, but there's nothing wrong with notarizing it, right? So another question I get a lot is, well, okay, how quickly do I need to provide a lien release after I've been paid? And purely under Chapter 53 statute says within 10 days of your receipt of the payment, right? But what does receipt of the payment mean? Receipt of the payment does not mean the day you picked up the check. It means the date that money is actually in your company's bank account cannot be returned in SF. That's what that means. So it's perfectly okay for you to wait to make sure that check has cleared, even if that takes longer than 10 days, because the 10 days does not start until the money is actually received in your company's bank account. Do folks wait longer than 10 days to provide lien waivers on projects? All the time. If you can, if you can do it within 10 days, great. Is there some big penalty for not doing so? No, there isn't. There's not really an enforcement mechanism for this deadline. I just wanted to make you all aware of technically what that deadline is, 10 days. So what do you do in this situation if a GC or a customer sends you a lien waiver that doesn't look like the ones we just talked about? It is not one of these 4 statutory forms. My advice under those circumstances is, we talked about it's illegal for them to actually require or try to use, and for private projects specifically, it's illegal for an owner or customer or anyone in the construction chain for that matter to be trying to use forms that are substantially different than these forms we just talked about. So what do you need to do? Make sure you have copies of these statutory forms. Make sure you know which one to use and when. When you get the form that it doesn't look like, honestly, when someone sends you a form, you pull up your forms, you say, oh, okay, this is the statutory form. You pull up yours, you compare, you go, okay, yeah, they sent me the right form. Or if you pull it up and it does not look like the statutory form, just fill out the statutory form instead and send it to them. That's how you handle that situation. Don't think you have to use a manuscript form that's provided by a GC or owner just because they sent it to you. You don't. If it's something that doesn't look right to you, says stuff that you don't recognize, does not look like the statutory form, just use the statutory form instead. That's the way we handle it. Language particularly that's troublesome in these, the reason why we have these statutory forms is because owners and GCs were putting in onerous language in these manuscript waivers. They were putting in very broad form waivers that would say you release any and all claims of every kind against owner and GC. They would state that your company would defend and indemnify and hold harmless the owner and GC. All of these very broad waivers, much more than just waiving your lien right for a payment received. The only thing an owner or GC is entitled to in exchange for paying you for your work or for a product or material provided is they're entitled to a waiver to your right to file a lien because you've been paid. So you can't file a lien for something that you've been paid for. They're not entitled to broad form waivers. How can that impact you later, these broad form type of waivers? They waive any and all types of claims. So let's say there was an injury on this job, a serious injury on the job. And then there's a lawsuit coming later based on the injured worker files a lawsuit. And a lot of times these plaintiffs' lawyers sue everybody in the construction chain, right? Based on the injury. And so they've sued your company as well. If you've signed one of these waivers that said you have waived any and all claims of every kind, and it turns out that obviously the injury had nothing to do with your company, so you would make claims back against the owner or GC because it was probably their fault, you probably just waive those claims, right? Or you've arguably just waived those claims. That's the argument that would get made. So you've got to kind of, that's the risk with these manuscript, these waivers that are just written by the attorneys for general contractors or owners. The reason why we have the statutory forms is to avoid that type of risk shifting. So again, if you get one of these waivers that looks really weird and says stuff that looks a lot different than those statutory forms, just use the statutory form instead is the best way to go about it. And that's really all the comments that I have for you guys today. I'll be happy to answer questions if anyone has any.
Well, Rebecca, you are a delight as always. You have a lot of great information for us, so thank you so much. We do have a couple of questions that came through. There's a couple about different, releases and stuff, and then there's a couple that are about bonded projects. So I'm going to go through them for you, okay? The first one, it says, should there be a through date listed on the releases, not a down date?
Through date or down date is the same thing in my mind.
Thank you.
Just date from which that the waiver is effective for everything supplied before a particular date. So through date, down date, same thing. That's, I would say either or, it's very same thing. But should you have one, that's up to you. The danger in using a down date or through date rather than just specifying which pay application is being paid or specifying which invoices are being paid is that if you miss something, there actually was work that you intended to bill for but didn't and try to bill for it later, you probably just waived that right. That's why I think the clearer way to do it is just to that following extent, to where you fill out the portion that says to the following extent, you just tie it specifically to the pay application being paid or the invoices being paid.
Right.
Now, on the flip side, if you're a general contractor or you're an owner, would it be better for you to have that down date because that's shifting the risk to the supplier or subcontractor to say, hey, you better be right. Don't come after me for more money later. You may want to have a down date or through date. It's depending on your perspective in the construction chain, right?
Perfect. And then the next question, it says, is the statement a required form that needs to be added to the waiver on the third month fund trapping notices?
On a fund trapping notice letter, so the lien process for the statutory form of notice that's required for a Texas-based private project fund trapping notice letter, do you have to have a statement attached? No, you do not. Do we normally attach copies of the invoices to the ones going out from our office? Yes, we do.
Right.
Do you have to absolutely have a statement attached to a private project statutory form fund trapping notice letter under Texas law? No, you do not. And there's no form.
Perfect. Thank you. Okay, awesome. Thank you. We do have a couple of questions, like I said, regarding some bonded projects that I'm going to pose to you. It says, is the subcontractor required to send the second month bond claim notice before they send the third month bond claim notice, or did the laws change in 2022?
The law that eliminated the second month notice or the preliminary notice only applies to private projects. Government jobs, specifically state or local government jobs governed by Texas Government Code 2253, that second month notice is 100% still required. Yes, 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 please send it or you won't have a good bond.
Perfect. Awesome. And then the kind of follow-up question, and this is on the public bonded projects, is there a time difference between first tier and second tier subcontractors or suppliers in sending the second month bond notices or the third month notices?
No, it's going to be those deadlines. The deadlines for sending notices are for Chapter 2253 bond claims run from the date you provide the labor or supply the materials or do the work on the job. Doesn't run from your invoice date, doesn't run from your pay app date, it runs from the date that the work was done. And so then you have to send those notices by, you're counting your months from the month the work was done. So if you're doing work in January, February, March, that's when that preliminary notice has got to go out on or before March 15th. Your bond claim then has to go out by the April 15th, on or before April 15th. And those deadlines under Chapter 2253 are for quote unquote each month. So you got to keep sending the notices. If you keep doing work, you got to keep sending the notices, and you may have to make more than one bond claim if you continue to perform on a job, even though you aren't getting paid. You might have to do more than one claim. Whereas with mechanics lien statutes for the actual lien filing, you can wait until the 15th day of the fourth month after the last day you did work and only file one mechanics lien. That's not how it works in bond claim world.
Okay. Is there any difference on a private bonded project instead of a public bonded project as far as those differences?
The forms are 100% different. The deadlines are different. So for a private project that is bonded, so it's got a subchapter I payment bond under Chapter 53. That is a bond to pay liens and claims. The deadlines that relate to that bond claim are the same that relate to a lien claim. So there is no second month notice at all required. But your third month notice, your fund trapping notice letter in the statutory form needs to go to the surety as well as the other parties in the construction chain.
Okay, wonderful. And then this is still talking about the public bonded jobs. Are there retainage notice requirements for public bonded projects?
Yes. There are very specific sections of Chapter 2253 that deal with how to notice for retainage. And there's specific language that the notice needs to require. It needs to include.
Okay, wonderful. And then this is about private bonded projects. Should you still send the third month fund trapping notice in addition to the third month bond notice?
If it's a private project that is bonded, your bond claim notice is the fund trapping notice letter. There's not two separate notices. You don't need two separate notices. What you're doing is sending the bond company, in addition to everybody else in your construction chain, a copy of your statutory form fund trapping notice letter. That is the bond claim.
Okay, wonderful. Thank you for that clarification. And then it looks like this might be their last question. It says, are there retainage notice requirements for for private bonded projects?
Yes, there's specific when we're talking about the statutory form for a fund trapping notice letter, third month notice, there's a separate statutory form for retainage. So there's a whole, and it's word for word in the statute. So if you go look at Chapter 53, what you're going to find is there's a retainage notice for contractual retainage as well. So just look that up, or I'm sure SunRay can provide it for you.
Perfect. Thank you so much for that. I appreciate that. That does appear to be all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Rebecca, can you go to the next slide for me, please?
I can.
Thank you. All right, so here are some of SunRay's resources to help you stay organized and know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. They'll be there to help you kind of stay organized and know what you got going on, know who all the different entities are from the beginning by using that project information sheet, knowing what those deadlines and the documents are that you're required to send. So scan that and see what you can find on there. All right, next slide for me, please. All right, our next webinars with Rebecca are going to be April 24th, Mechanics Liens, Texas Style, Deadlines and Forms of Notice to Get Paid. And then in August 28th, I filed my Mechanics Liens, Now What's, turning that lien into dollars. So please sign up for free at sunraynotice.com/education. We hope to see you guys there. They're going to be really great topics to kind of learn about. Next slide for me, please. All right, so if you are going to be in the Dallas area in May 30th, we are going to hold a live seminar with Rebecca. It's going to be Rebecca and Ariella from SunRay about how to get paid faster with liens, bonds, and contracts. It's going to be a great event. It is a 2-hour event that you'll be able to listen to them speak, kind of give you the tips and tricks, and then follow up questions and all of that. So we hope to see you guys there. So please go ahead and register at sunraynotice.com/seminars. And we'd love to be able to see you guys there. Next slide for me, please. All right, and if you don't mind, give us a quick review on Google. We really do appreciate any feedback you can provide to us. It helps us always better ourselves. So if you could just scan that and give us that quick review. And then the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much to everyone who attended. We hope to see you at our next webinar.